So the way you buy a house involves more than just picking the name that you want to go onto the deed. It could be kind of complicated depending on your marital status, the arrangement with whomever you have the house that you're buying or potentially buying. Let's talk a little bit about, the name you put on the contract versus what you want actually recorded on the deed. What are some of the pitfalls that could go into that?
Well, I think I really learned a bit about this area, not as much from being a lawyer, but just as a person. You need to, as the sort of overarching principle as we talk about this, and for our clients to think about, is probably the default way a title company will set up title for you, if you do nothing else, is not what you want. Look, keep in mind, they are an insurance company, right? They're going to do what sort of is easiest for everybody, default the way they normally do it, in the least amount of work, and the easiest on the insurance side. Okay.
Sure. And unless you tell them otherwise, they're just going to presume that, kind of
the
everyone
default
is the default. Yeah.
Right. Well, that's exactly right. And so I just think, hey, listen up. If you're thinking of buying a house, and especially if any of these things apply to you, if you're divorced, if you're remarried and part of a blended family, if you're buying a home with someone who is not your spouse, if you're buying a home with a spouse, if you're buying a home in the name of a business. Okay, so here's the main thing to
Sounds like everybody.
Yeah, that's yes, it's all of y'all. So the main thing to keep in mind or to consider is whether you want a right of survivorship. Now what that means is, with the people on the deed, however they're set up, probably if they're unmarried persons, brothers, sisters, business partners, affianced, people who are engaged, okay, they are going to take as tenants in common. And what that means is, like in general, two people who have the right then to divest themselves of their interest. So your fiance could sell, if something happens and y'all break up, sorry, they can sell their house, right? Or if they pass away and they don't have their estate planning handled, maybe their child from a previous marriage or their mama or their sister who you hate may then become your owner, okay? The
Better
way
pick
around,
carefully.
yes, watch out. Everybody heard the mother-in-law part. And they're like, what they want to consider is getting a right of survivorship in place. And so what that means is, so these two people who took as tenants in common, then if one of them passes away, what'll happen is it doesn't pass down to their descendants or by their estate plan. Instead, title vests automatically by operation of law in the other person. So I personally experienced this, okay? I'm divorced. With my now husband, we bought a house before we were married. And we sat down went to the title company, do the whole thing with all the folders and all the papers. And I was looking and I'm like, wait a minute, this doesn't have a right of survivorship. I'm literally a lawyer and thought about it the morning of when I sat down at the closing table. Weird. I really don't want this to just be tenants in common or just us as co-owners. Because what if something happens to me? I don't yet have all my estate planning together. I'm like the plumber with the leaky faucet at that point. And if something happens to me, my interest in this property would go to my children. And then, with my ex-spouse, have and then have a conflict with my fiance, who's now my husband. So I'm like, oh my God, I have to have a survivorship agreement. And the title company, to be honest, was pretty sassy with me. I mean, I should have thought of it before, to be honest, but they like, oh, right of survivorship, like how could I dare even think of this, okay? And they had to go draft for another several $100s a survivorship agreement between my now husband, my fiance then, and I, where if something happened to either of us, title would vest in the other one and avoid the whole potential drama. Okay, so think too, if you've got a business partner, do you really want to be fighting with their spouse? And what if they don't have all their estate planning handled? So you can do this survivorship agreement, and there's some technicalities, so you do need a lawyer or real estate lawyer, somebody to help you with that, but have this agreement that says, we want it to go to each other, or maybe you don't want it to go to the other person. You need to just think about it with some intention.
Sure, the point is have conversations before it becomes a problem on the back end.
Yeah, and I think also for husbands and wives, let's think about that, especially in the blended family context, okay? Because in Texas, we're a community property state, which is in the minority. I know it's hard to think like this big, huge state that we're in the minority, but it's true. Where whenever you are married, everything you earn or acquire during the marriage, that's not a gift or an inheritance, is both of y'all's. It doesn't matter whose name it's in. It doesn't matter who got it first. It doesn't matter if the other person's never even logged into the account. Okay, this is like number one. No one understands this until it's too late and you're like in a divorce. You create this community property, and if you're married, depending if you're a blended family, contrary to what people may think, if the spouse dies, all of the house or all of the assets don't just go to the spouse, because you've got kids from a prior marriage to consider. Okay, so you, especially in that situation, if you're married but have kids from a prior marriage, I bet what the state of Texas would do with your stuff is not what you meant. And so what some people do is they may say, well, I want my spouse, I don't want them to have to move out. So I want to take title as husband and wife with a right of survivorship and do the technicalities, both signed, acknowledge it. So that way, at least the house stays with my spouse, and my other accounts I may leave to my kids in equal parts. That's a common thing that people want to do. I don't want him to lose the house. I don't want her to be on the street and not in this house we bought together, okay? So if you're from a blended family, and look, even if you're not, and you're just what I call a four corners family, and you're a husband and a wife buying a house, go ahead and put the survivorship agreement and that intent, that express intent, into the deed, because it's not presumed that you want that. So you have to actually manifest an intent, right? Show that, attest to it. Go ahead and put it in there. That way you save a step in the probate process of having to do anything. Just by operation of law, death certificate, and right of survivorship, it's the other person's.
Right.
This also, just FYI, applies to bank accounts and things that you own. I always recommend that people who do estate plans with me go do an audit of all the different bank accounts that you have. And it's a piece of property that you own and take title to. I bet you it is not default payable on death, like you've seen POD, right? Or a right of survivorship is basically what that is. A good idea for most people, talk to a lawyer to see if this is true for you, but for most people is to go ahead and make that account payable on death so you don't have to wait through that whole probate thing we were talking about, and take it with right of survivorship. So I think if you are buying a house and you've got Melissa and squad helping you because you're a very smart, educated home buyer, and you want to consider this, and don't just expect that the title company is going to do what you want, because probably they aren't. So it's a good time to have a conversation with a lawyer like me, or if you have super complicated, like a real estate focused lawyer, to say, hey, how do we want to take title? If we do the default, what will that mean for us? And you often want to do that before you even do the contract. Okay, this
Absolutely.
is a pre-planning step that clients need to do, because you may want to go ahead and write into the contract as tenants in common with the right of survivorship, or for a husband and wife, okay? Because it can affect the cost of title insurance and things on the back end.
Sure. So I think the great takeaway is have a plan early, and that really, in part of creating wealth and also protecting your wealth is making sure you have a good established plan, and cross your T's, dot your I's, and double check it so that everyone can be protected properly.
Yeah, you go through all this stuff. Don't just leave it up to chance, or up to the state, or up to your ex-spouse.
For sure. If you have any questions about buying a home or properly protecting your estate, give the Real Estate Muses a call, and we'll get you in touch with Hannah Bell.